Okay, well, welcome everyone to EFA Talks, our monthly get-together with members and guests to talk about topics of concern in the digital rights space. I'm Rita Mack, Vice Chair of EFA, and your host for today's talk, Government Hacking Powers and Policing. Firstly, Electronic Frontiers Australia acknowledges and pays respect to the past, present and future traditional custodians and elders of this nation, and the continuation of cultural, spiritual and educational practices of Aboriginal and Torres Strait Islander peoples. So, in our talk today, we will be looking at the implications of the proposed surveillance legislation amendment, Identity and Disrupt Bill 2020. The bill, if passed, would hand the Australian Federal Police and the Australian Criminal Intelligence Commissioner 3 new computer warrants for dealing with online crime. Our panellist today is Dr. Monique Mann, a senior lecturer in criminology and a member of the Alfred Deakin Institute for Citizenship and Globalisation at Deakin University. Dr. Mann is an adjunct researcher with the Law, Science, Technology and Society Research Centre at Verregae University, Brussels, Vice Chair of the Australian Privacy Foundation and Vice President of Liberty Victoria. And also I'd like to introduce Chair of Electronic Frontiers Australia's Policy Committee, Angus Murray. And Angus is a partner and trademarks attorney at Irish Bentley Lawyers. He holds a published Master of Laws from Stockholm University and lectures Law 3418, Law, Technology and Your Future at the University of Southern Queensland. He is also a co-founder and director of The Legal Forecast, a member of the Queensland Innovation Committee and the IP and Technology Committee, and Vice President of the Queensland Council for Civil Liberties. Welcome and thank you both for joining us today. Excellent. So I just want to let everyone know that we will be answering questions towards the end of the panel, so please use the chat if you've got any questions at all. Now, Monique, before we dive into the bill, I would first like to ask you about the social and legal research work that you've done on the privacy and human rights implications of police technology and the transnational online policing.
Excellent.
Big thing to start with.
Thank you, Rita, and thank you to the Electronic Frontiers Australia group for inviting me to appear on this panel today. I'd also like to start by paying my respects to the elders of the traditional, or the lands on which, the traditional owners of the lands on which I'm broadcasting from today, the Wadawurrung people of the Kulin Nations, before getting into the content we will cover. So in terms of my research over the previous 5 or so years, this has really aligned with kind of an explosion or hyper-legislative approach adopted by the Australian government in the area of electronic or telecommunications surveillance. Really aligned, I think the first was around the introduction of mandatory metadata retention laws, back in 2013, 14, 15, that require internet service providers to retain the metadata and provide warrantless access to a whole range of agencies. And so what I'm going to do is I'll speak to some of my, my research program and my agenda in these areas, but I'm also going to put into the chat links to open access publications where interested attendees and panelists, other panel members can go and read them in their own time. So really, my coverage of the sort of metadata issues, looking at areas of privacy or criticisms of privacy and security imbalancing and notions of digital security, digital constitutionalism, was published a few years ago. There's an open access version of it. Subsequently, I started researching sort of some of the jurisdictional implications of surveillance or surveillance across borders. I edited a special issue of the Internet Policy Review with Angela Daly that was recently published, with a whole range of articles dealing with that in particular, and also focusing on the Australian Assistance and Access Act, so the Australian government's attempts through ask access to undermine encrypted forms of communication as well. So you can read that. Particularly, we pay attention to the extraterritorial implications and the way in which Australia operates as a weak link in the Five Eyes network, allowing the circumvention of other laws elsewhere, or constitutional rights frameworks that other countries have that we don't have here in Australia, to kind of exercise these surveillance powers. In terms of extraterritorial government hacking, which is what we'll be focusing on today with regard to the Surveillance Legislation Amendment Identify and Disrupt Bill currently before Parliament, I have done some work with some of my colleagues, Ian Warren and Adam Molnar, concerning a case study where we looked at the FBI's approach to extraterritorial government hacking in the Playpen investigation, and we've published that in, again, the open access journal Surveillance and Society. And we've also written an associated conversation article speaking to some of the legal dangers of dark web policing, particularly as it occurs across jurisdictions. So I just wanted to provide some links to this published work here for context and for homework for interested attendees, but then jump straight into sort of the issues in relation to the proposed government hacking bills, and talk about sort of some of the powers that it may authorise or that the bill will allow for, some of the issues, and then we can kind of open it up to a sort of a panel discussion with Angus as well. So the Identify and Disrupt Bill, currently before Parliament, it was referred to the Parliamentary Joint Committee on Intelligence and Security. They held some hearings on that. We're waiting for the final report. It provides for 3 new powers. These include data disruption powers, which authorise the exercise of offensive data disruption powers to frustrate commission of offence using a computer that is punishable for a maximum penalty of 3 or more years imprisonment. And Angus and I will come back and talk about this threshold of 3 or more years because it's quite a significant one. So according to the explanatory memoranda supporting the bill, these are warrants, quoting here, that enable the AFP and the ACIC to disrupt data by modifying, adding, copying or deletion in order to frustrate the commission of serious offences online. Very similar to some of the language in relation to assistance and access. As Angus and I noted in our submission to the Parliamentary Joint Committee on Intelligence and Security, I mean, look, it's really dangerous to enable law enforcement to modify evidence in criminal proceedings, and that's kind of one of the main concerns that we've raised, and we'll speak to more, I guess, in the panel component of this talk. The other kind of addition or new power that is being proposed in this bill is what is known as network activity warrants that enable the ACIC or AFP, again noting law enforcement, not intelligence agencies, to monitor the computer-related activities of criminal groups, and I'll talk about the definition of those momentarily, for the purpose of collecting intelligence rather than investigating an offence to obtain admissible evidence. And really, in terms of the definition of criminal group, this is defined as an electronically linked group of individuals, which means 2 or more people who use the same electronic service, which could be also a website, to communicate with others or to communicate electronically with a group. And I mean, this could be anything effectively. It's so broad and expansive as to be effectively unlimited in scope in practice, and it could apply to individuals that have really no or very loose connections to any suspected criminal offences. Very loose potential connection to criminal activity. The final warrant is account takeover warrants. These authorise the AFP or ACIC to assume control of an online account that is suspected of being used in the commission of offence punishable by at least 3 years imprisonment. And this grants law enforcement the power to alter and remove individuals' access to their online accounts. Again, really problematic for a whole range of reasons, and really represents, in my view, significant expansions of the existing powers of law enforcement agencies, not intelligence, not the ASD, although with the assistance of the ASD, of their existing powers, away from a traditional focus of investigation and the collection of admissible evidence of specific offences, to disruption, to attack, to takeover, to takedown. These typically are powers that are reserved for the ASD. Here, the distinction between intelligence and evidence and the activities of law enforcement and intelligence or signals intelligence agencies is being eroded. And this comes with democratic costs, impacts on liberties, obviously privacy, but others, such as freedom of expression, freedom of the press. And we'll discuss that more. So I think I'll leave that as my kind of brief overview, and then we can come back and talk about some of the kind of key issues in depth.
Absolutely. Thank you, Monique. That's quite a range that we've just covered there, but we're just going to bring this back to the submission, which Angus, I'd love you to talk about. Now, this was a collaborative submission involving Australian Privacy Foundation, Digital Rights Watch, Electronic Frontiers Australia, FutureWise, Access Now, Blueprint for Free Speech, and GetUp. So, Angus, this was quite a feat. Can we just talk a little bit about that process and, you know, the fact that there was just no time either?
Yeah, thanks, Rita. And it's great to have Monique involved in this conversation because she's been a co-author on each of these submissions and a significant contributor to the body of work that EFA has done alongside many other civil society organisations. And you're exactly right that one of the themes that seem to appear consistently with respect to digital liberties and surveillance legislation is bills that amend the telecommunications legislation infrastructure and the way that surveillance law operates in Australia seemingly have to be introduced very, very rapidly with the justification that there's an imminent threat or that there is something that's looming on the horizon that must be dealt with, and the only way it can be dealt with is intrusive powers that effectively allow a government to monitor the activities of citizens within the state. The Identify and Disrupt bill is the most recent of these pieces of legislation. As Monique said, this development of surveillance legislation in Australia has a relatively long gestation, but in the last 7 years, there has been a particularly sharp increase in the number of bills that have been introduced and the powers that have been vested into not just the Australian Signals Directorate, the ASD, but across a wide range of policing bodies and agencies in Australia. The Identify and Disrupt bill is particularly problematic, and as we pointed out in our submission, it's come very, very rapidly and in very close proximity to the assistance and access legislation that was hotly contested and dealt with technical capability notices, technical capability requests, and effectively had the impact of allowing a government a side door into technology in a very, very, very broadly defined context of designated communications providers.
Yeah.
Identify and Disrupt legislation gives 3 new powers. As Monique said, the account takeover, data disruption, and network activity monitoring warrants. It was introduced late last year into Parliament by Peter Dutton, and I think his involvement in the bill probably speaks volumes about the substance of the bill. Mm-hmm. He, when introducing the bill, required the bill to be considered by the Parliamentary Joint Committee on Intelligence and Security and have a report before the August sittings of Parliament because it needed to be passed rapidly. The submission that Monique, Dr. Mann, myself and a number of other people contributed to that was provided to the PJCIS, Parliamentary Joint Committee on Intelligence and Security, in February this year, specifically requested our presence at a hearing of the submissions. We, nor any other civil society organisations, were afforded the opportunity to participate in the hearing, and that was even queried with the Secretariat of that committee as to whether there would be opportunity to that, and expressly we were told that there wouldn't. It's curious that the participants to that hearing were predominantly, and the vast majority, government agencies, particularly agencies in the portfolio of Peter Dutton. The only submitter that was invited to give evidence to that committee that stood effectively from a human rights and liberties perspective was the Australian Law Council, and their submission was excellent. But it's my view very firmly that civil society must be included in these discussions, and everyone listening certainly should be alive to these issues, because as Monique very accurately said, democracy is directly affected by these powers. And it's critically important that the safeguards that we have in Australia, which is effectively the will of the people, remain at step with the actions of government. In the context, and we'll come to this in a moment, of what happens once these bills are introduced, it's very, very rare that Australia repeals legislation. In fact, there's recently been a review of the corporations legislation and a finding that effectively large swathes of that act are now redundant or are overcomplicated and are the subject of too many instruments and regulations running alongside the Corporations Act that it's no longer actually fit for purpose. That is a symptom of the way that Australian law operates. Something is introduced and then it stays. Each time we've introduced these surveillance laws, we've incrementally increased the power of government without balancing them out against something else. And we don't, as has been said in every submission, from 2013, when the mandatory metadata legislation was introduced, to date in relation to surveillance powers, we do not in Australia have a fundamental human rights framework at a federal level, and we have at best very weak protections for our liberties as Australians as regards an interaction between us as citizens and the state. And if we compare and contrast that with our friends in Europe, I'll drop a link into the chat as well. It was a Grand Chamber of the European Human Rights Court decision delivered yesterday in Big Brother Watch in the United Kingdom, which upheld a finding that the Snowden revelations revealed surveillance techniques en masse used by the United Kingdom that contravened Article 8 of the European Human Rights Convention, that is the right to privacy. That's a very important decision because it says these powers have a serious impact on human rights. It's an even more important decision from an Australian perspective because we don't have those protections. So rather than launching too far down that path, Rita, I'll bounce it back to you so we can start a discussion between myself and Monique about this.
Well, thank you, Angus. I mean, we keep coming back to the same sort of themes, isn't it? Is that our democracy is just obviously, it's not functioning appropriately in this kind of environment. But first of all, I just want to take it back to, as we can see, that our legal framework, it's a mess in terms of digital rights. But I just want to add a little bit more on how we talk about the extraterritorial scope, and that impacts on the rule of law. So we're so vague, everything's vague, isn't it? It can be interpreted in multiple ways. How does that then translate in that international framework, Monique?
Yeah, really good question, Rita. And look, the kind of powers that this bill seeks to introduce and their successive kind of, I think, combination or how they'll play out in practice, it's very interesting and in my view, very similar to what we saw in the FBI's takedown or takeover and running of the Playpen website. Effectively, they hacked this network used for the dissemination of child exploitation material, continued to operate the site for a period of 2 weeks in which they infected everyone who connected to the website with malware, and effectively hacked thousands of computers in 120 countries with a single domestically authorized US warrant. And I think, look, there are a lot of issues with these forms of extraterritorial enforcement and surveillance. And I think it goes to the heart that, you know, these powers are by design an attempt to uncover, or so they say, dark networks, which we'll talk about a bit more, I think, in terms of some of the limits or the scope of applicability around 3 or more years imprisonment, for example. But essentially, you know, these attempts to undermine or to uncover dark networks which operate via identity and geolocation concealing technologies such as virtual private networks and Tor. And effectively, while using these technologies, the physical location of the target computer and suspect means that they're not known by, for example, Australian law enforcement in advance of the exercise of the powers. So you have that on one hand. On the other hand, the powers of Australian law enforcement are limited to the sovereign jurisdiction of Australia. And so the proposed government hacking powers here effectively extend the reach of Australian law enforcement outside the sovereign jurisdiction of Australia with significant extraterritorial impacts. And they also require Australian judicial authorities and the AAT to authorise extraterritorial law enforcement operations outside of the scope of the lawful jurisdiction to do so. And this really means that there are due process risks for suspects that are located out of Australia. And in the event that you know, this does proceed to criminal prosecutions, they could effectively be jeopardised, which is what we found in our published research concerning the Playpen cases. So in the absence of any clear transnational regulatory structure or framework supporting government hacking operations in cases where the physical location of the target computer and suspect is not known, these types of laws should be reconsidered because they go to issues of the rule of law, the lawful jurisdiction of law enforcement agencies and judicial authorities, and have really significant due process implications. So, I mean, I think that's kind of one issue. There are also the kind of geopolitical dimensions of this as well. You know, the geography defines scope of legitimate exercise of state powers, important for due process and protections, but there's also these geopolitical considerations. So we wouldn't be happy, for example, with North Korea hacking the globe and encroaching on other nations' sovereignty. So why is it okay for Australia or, you know, the US to do it? And so I think that's kind of a real kind of issue and consideration here. In terms of this requirement around the seriousness of offence of 3 years, just going to that issue, 3 years imprisonment, it's a very low threshold that's not consistent with the rationale supporting the justification for the introduction of the powers, which is to target child exploitation material, the dissemination of CEM or terrorist offences. And the bill is drafted so broadly, and there's, I think, here potential for overreach, and that the breadth of the definitions means that the warrants can be used to target very minor criminal activities, as well as those of individuals acting in the public interest. So, for example, journalists and whistleblowers. And we know the Australian government has taken a particular stance towards coming after journalists reporting in the public interest. And I think here, that's really clear. The risk of applicability to journalists, to activists, to academics, and indeed the Australian Federal Police raided Annika Smethurst for her reporting and her coverage on this exact issue, the introduction of this bill, Identify and Disrupt. The story that she broke leading to the raid on her house was regarding the very expansion of surveillance powers reserved for the Australian Signals Directorate, or the involvement of the Australian Signals Directorate surveilling Australian citizens, which is really somewhat of an irony, actually, that now this bill is introduced that allows for sort of these new powers of law enforcement supported by ASD to do exactly what she was reporting on.
Yeah, if I can just jump onto the back of that and really reinforce the point about...
Can I just step in just for a quick moment? Sorry, Angus.
Yeah.
Is with that extraterritorial scope that we've just been talking about and all that sort of stuff, can we just lead a little bit into the Richardson Review? Because that's kind of like, that's sort of in a mess, and then we've got these other things sort of happening. So we've got, it's a very sort of dangerous situation, Angus.
Yeah, so the issue that I see with the mess that's being created, in effect, with surveillance legislation is legislation has to adhere to a parliamentary intention. So Parliament has to intend something when it introduces legislation. As Monique said, an intention to introduce legislation that deals with child exploitation material or to combat terrorism that has a scope that is extremely widely defined, and by the assistance and access legislation amends the definition of computer to effectively mean the internet, puts us in a situation where, firstly, the scope and the full power of law is not actually understood. Secondly, the courts are left to guide the community in terms of how the law is ultimately applied. And thirdly, it's unlikely that this legislation would be repealed once it's passed, and I fully expect the Identify and Disrupt legislation will pass. The Richardson Review comes to a series of recommendations, effectively finding that our landscape, electronic and privacy landscape, is in a shambles, and that protections aren't sufficient to combat the situation that we find ourselves in Australia, effectively in an e-commerce and digitalised world. I think the Richardson's report is something that everyone should read, or at least be aware of, and I think it's incredibly important to see that in the context of, on one hand, we have a very, very rapid increase of surveillance legislation and a very, very intrusive set of powers granted to law enforcement. And might I say, a lot of those powers are not the subject of judicial warrants, and many of them are subject to warrants that can issue by the Administrative Appeals Tribunal, which is not the Chapter 3 court.
Angus, for people who might not know what the Richardson Review or what that's about, can you just give us a little bit more of an idea?
Yeah, I'll bounce that to Monique, because I know Monique's done quite a bit of work on this, so I won't cut across her.
Yeah, that's all good. So, I mean, in terms of the Richardson Review, it's been going for a couple of years. In December last year, well, the Richardson Review is kind of the shorthand explanation of the name of it, but it's called the Report of the Comprehensive Review of the Legal Framework of the National Intelligence Community. It was released publicly in December of 2020, so that's the declassified version. The classified version was completed a year earlier, but then it took a year to redact, I think. So it's a four-volume report. It's 1,300 pages long, and it made 190 unclassified recommendations, 13 of which are classified, an additional 13 classified. And so effectively it covers a whole range of recommendations in terms of authorisations, immunities and electronic surveillance, information technology powers and oversight, accountability and transparency across the 4 volumes. The key recommendation arising from the Richardson Review was to consolidate, or to enact a consolidated Electronic Surveillance Act that consolidates the Australian legal framework in relation to telecommunications surveillance, and 57 of the recommendations of the review go to that point alone. So effectively, it's argued that the Surveillance Devices Act, the Telecommunications Interception and Access Act, those parts of the ASIO Security Organisation Act governing the use of computer access and surveillance devices powers should be repealed and replaced with a new consolidated Electronic Surveillance Act. And that requires the repeal and rewriting of about 1,000 pages of existing telecommunications surveillance law. And really, the whole point leading to this review is because the TIA Act, developed in 1979, has not kept up with the scale and pace of technological change. It needs to be updated. It's no longer fit for purpose. So I think moving forward, this landscape in the Australian context is going to be changing. I think it's going to take time, a long time, to do a lot of that repealing and rewriting. And this is where we really need people to show up, to speak up, to make submissions from a range of different interests and a range of different groups, civil society, in my experience, very much screaming out for volunteers and to have people help in terms of drafting some of these submissions. And Richardson Review kind of contains some interesting recommendations. So on one hand, it was recommended that the Australian Federal Police and the Australian Criminal Intelligence Commission shouldn't have these types of government hacking powers for a range of reasons, some of which Angus and I have outlined here today. But on the other hand, it's also kind of some concerning recommendations and proposals coming through. For example, ministerial authorisation of ASIO and Intelligence Services Act agencies' activities without judicial or other independent authorisation. So look, this is going to take time, I think, to really work through and pass its way through kind of various stages, kind of moving forward, and something I think we should all be kind of very watching closely and paying attention to, and kind of being heard on these matters from a range of different perspectives.
Excellent. Angus, would you like to jump in there? I know that you've got quite a lot to say.
Yeah, no, I think it's an interesting, I think the Richardson Review is an interesting process that's been undertaken. I don't share the optimism of Monique that there will be a change in the sense of consolidating legislation. In my view and experience, it isn't ordinary for government to attempt to make things easier. The reason why it's scattered out at the moment, I think, is to give power across a variety of bases. And law that's confusing is law that can be applied without people appreciating its consequences. It is interesting, as Monique said, though, there are contradictions in the Richardson Review. It's also important, I think, to see the Privacy Act review that was recently undertaken as well, because that's, I think, the counterbalance that we have at the moment in Australia as against the powers that government's rapidly introducing. And it's interesting to see how a lot of the reporting of the PJCIS around surveillance legislation acknowledges the issues and engagement of international law and an understanding of human rights. But at the same token, and it isn't the scope of the PJCIS to do this, doesn't push for something to balance against these legislative frameworks. There's a point in all of this, because we're talking effectively about surveillance legislation and surveillance en masse. I was fortunate to give evidence in relation to the assistance and access legislation before the Independent National Security Legislation Monitor, Dr. John Renwick, QC, as he was a couple of years ago. There was a question that arose in that evidence to do with the submission that EFA had put being the only submission that had raised the concept of the Telecommunications Other Legislation Assistance and Access Act being used as a form of mass surveillance. And I took the Security Monitor to task on that, because that submission had some 12 authors across 9 organisations. And the point that's made in that submission, and I think should be really reinforced, is even if the legislation doesn't specifically cater for or direct intelligence agencies to mass surveillance, any legislation that has the potential to be used as a form of mass surveillance in the future should be very, very carefully scrutinised. And that's really the context of where I think the Richardson Review should be aiming, is consolidating and ensuring that abuse of legislation cannot occur. It will be interesting to see how that process unfolds, though, and it was only December last year that the report was released after its iterations over the last couple of years. But it's certainly a place to watch.
Yeah. And I think just, Angus, you mentioned it earlier, the recent sort of decision in, European Court of Human Rights around Big Brother Watch and others around sort of bulk surveillance and so forth. In that context, post Snowden's revelations. I mean, the fact that it's even going to a court of human rights in the Australian context is just not possible, because we don't have sort of these robust human rights frameworks here. And I think that's sort of another kind of elephant in the room, that we lack kind of these mechanisms to provide adequate protection against the abuse of surveillance powers, not only the ones that are contained within Identify and Disrupt, but all of them, all the very many of them that we've seen that have been introduced in quick succession over the previous 5 years. And so I think, I bang on about that quite a lot when I give these talks. We do need this kind of overarching human rights, enforceable human rights framework at a federal level. I think that's a real serious gap that we have in the Australian context.
So if we see at the moment, we don't have it, right? And I think the elephant in the room, we're just sort of naming the game pretty much of what it is. We do not have a proper democratic process in place that we can ensure that there's checks and balances and power is held to account. So from that sort of point of view, if we're sort of looking at the fact that these bills are just being passed, we're seeing patterns occurring, we're seeing how the legislation is so broad. Angus, we're going to move into the future, because I know you're very good at future thinking here. Let's just talk a little bit about what the future would look like if we don't do something about these ridiculous overreaching bills that are just coming through at the last minute.
I think it's useful to look to what Europe's doing as a guide, and I've described Australia's privacy and human rights landscape as immature against the maturity of the European system. I don't think Australia's heading in a direction like the European Union, and I don't think that we should be blindly adopting things like the GDP, the General Data Protection Regulation in Australia, because I think our context is different because of the way our law has evolved. It's interesting, I think, that the concept of a tort for serious invasion of privacy has been used a number of times. The High Court expressly ruled out the possibility of a tort for privacy invasion in ABC and Lear game meets in 2006, and left Australia in a situation where we have an idea of an obligation of confidence between people, and that's sufficient in Australia in the minds of the courts at this stage to protect against privacy breaches. I suspect into the future we will find a tort for serious invasion of privacy in Australian law, and I think that will serve as a very important balance against some of these powers. I also suspect, given that Victoria, the ACT and Queensland now will have state human rights acts, all fairly watered down and all without teeth, but each being steps in the process towards there being some human rights framework introduced at a federal level in Australia. And I suspect very much that once New South Wales comes onto the board with a Human Rights Act, there will be a push to have something introduced federally. And strategically, I think that's the way that we need to be thinking, is to push the states, to push the federal system to introduce legislation. It will be interesting to see how that ultimately unfolds. If we take, for example, the Canadian system, the Canadian courts have the ability to strike out legislation that's incompatible with human rights, the effect being the courts supersede the legislature. I highly doubt, although Canada is also a democratic country, that Australia would follow that. Our courts are very, very reluctant to interfere with parliamentary intention, because that is effectively the will of the people. In terms of making any of that happen, I am one person in a country of several million, but each person that you speak to that also becomes alive to these issues becomes another person amongst the millions. And the way that Australian democracy works is we are effectively our predictors and realisers of our own future. It's interesting, and I think we should come to this as well, that the safeguard that we have in Australia that's most direct is journalism and the ability for the press to report on what it is that government's doing and how powers are being used. So MyThirst is a perfect example of that, of a person effectively stood up and said, hey, something's wrong here, and ended up with the full weight of law enforcement being thrown in that direction. That speaks volumes, I think, about the way that government's approaching citizens. And as citizens being final barrier between government power and the abuse of that power, we should be very much alive to how journalists are treated, and equally how academics that are reporting and writing around this are silenced or shunned, or the subject of legal proceedings that effectively censor their ability to continue to operate and to make Australians aware of the issues that they're facing them.
Yeah, on that point, actually, Angus, and your question as well, Rita, around sort of the democratic dimensions of this. I mean, look, these bills are being drafted and passed through Parliament, they're being, through processes of democracy. But really, like, I think here there's a kind of a key argument to be made, and relates to the work of the surveillance scholar Lisa Austin. She made kind of similar kind of arguments post-Snowden, in terms of, what she calls lawful illegality. So you have a situation where surveillance actions are lawful. They're lawful because states are drafting and passing laws that allow for and authorise them. But on the other hand, these laws are inconsistent with the principles of the rule of law. So, for example, they may expand the scope of the reach of the jurisdiction or the state outside its sovereign jurisdiction. It may have all of these other kind of issues that are not consistent with the rule of law. So I think very much we do have that situation of lawful illegality in relation to a whole range of the surveillance laws in the Australian context, and indeed elsewhere. I agree with Angus as well, particularly given the impacts in relation to journalists and journalists reporting on various issues in the national interest, or in the public interest, I should say. And we did see, for example, with the mandatory metadata retention regime, the introduction of journalist information warrants that require law enforcement to obtain a warrant to access journalist information, to identify their sources, etc., etc. We see law enforcement, constantly failing to do that anyway. Introducing these additional protections for journalists, yes, that is important, but I think more broadly, we all deserve protection of our human rights, and perhaps warrants for access in terms of metadata would be a good first step for everyone. But I think here, real issues in relation to freedoms of the press, and this also relates to some research that I'm about to embark on, fieldwork interviews with journalists, with my colleague, Dr. Dermot Harkin at Deakin University. Also, we are seeking to interview journalists in relation to their cybersecurity practices and the impacts of the surveillance laws on their work and the way in which they go about their work. So if you are a journalist happening to be watching this interview today or this panel, please feel free to reach out to me at mann.monique, MONIQE, at protonmail.com, and we can provide you with some information about that project in terms of capturing journalists' views to kind of, advance academic knowledge in this area as well.
That's great. Thank you, Monique. We do have a question, so we're just going to put this out there. So will these new powers, if they're implemented, be audited regularly, potentially by a third party, to ensure they have not been abused?
I'll grab that. There are reporting obligations in each, the assistance and access legislation and the Identify and Disrupt bill, and if it passes, there will be obligations that the intelligence agencies that are collecting under those powers are reporting to Parliament. It's a really good question, because central in that question is transparency, and that transparency, I think, evidences the justification of necessity that law enforcement often runs when introducing these powers. The assistance and access legislation was very, very rapidly pushed through. Monique probably traumatically remembers the 2 weeks that we had to put together the submission when the bill was introduced. And it was a comprehensive, very, very detailed submission, but there was 2 weeks between the introduction of the bill and the submission deadlines, which is laughable, because that is an incredibly onerous task.
I've blamed that traumatic experience from my mind forever, Angus.
Compartments are a way of dealing with things, yeah. There's a very, very important aspect of this, though, which is rapid need for legislation, and the powers have to be used to protect against an imminent threat. The reporting around the assistance access legislation suggests that need was not actually present. There is very few uses of those powers. And although reporting is useful from that perspective of justifying the need, the reporting doesn't go to the heart of the use of the power, or the situation of the power, or where and how the power has follow-on effects. The other aspect to that question about reporting, I think, goes to transparency, and the Big Brother Watch decision that Monique and I have raised, the Grand Chamber delivered yesterday, right back at its first instance before the courts in the United Kingdom. There was a very, very important point made by the bench in that proceeding, in the reasons of that proceeding, that has been reiterated in a lot of our submissions, and that is, where you have mass surveillance and your targets don't necessarily know that they're being monitored by law enforcement, you have to be extremely cautious about issuing that power, because there is no check and balance inherently by its secret nature. So those kind of powers have to be vested in a court, and that court has to be scrutinising the use of those powers at a judicial level and at a fairly superior level. A lot of these powers are effectively going to be used, in my view, as tick and flick warrants run through the AAT, which is not judicial members. They're people appointed by the Parliament to sit effectively in this space. So I think that there's a lot that needs to be done around this. An aspect of that reporting as well, just to very lightly touch on another flavour of the submissions, is if we're going to have the AAT dealing with issuing these warrants, the AAT should be constituted with a judicial member, so a judge, and that judicial member should be assisted by someone from a technology background and someone from a civil society background to balance the human rights implication of issuing warrants and gaining access to these powers. Very interesting, very important question there.
Angus, I think just even listening to your description there, I think it really just shows the complexity, as even going to the Richardson Review here, and also the potential intersection of the numerous kind of surveillance powers, assistance and access, identify and disrupt, and I think that makes things even that more level of, I think, complexity, not only, granted the various issues in relation to unauthorized disclosure and sort of secrecy provisions protecting all of these activities, but also just the complexity of how they'll be used in practice. We didn't mention in the context of sort of the earlier overviews of other surveillance powers that are currently before Parliament, the International Production Orders Bill, the IPO bill as well, is, I think, a key one that we should also be, watching. The Parliamentary Joint Committee on Intelligence and Security has recommended that be passed. So that's kind of the next one, I think, that we'll see introduced as law. And that's a very key one as well in terms of enabling the Australian government to enter into a bilateral information sharing arrangement with the United States government under the Clarifying Lawful Overseas Use of Data Act, CLOUD Act, circumventing sort of regular mutual legal assistance treaty processes, which will effectively enable, the US and Australia to access digital information of citizens directly via US-based tech companies. So I think that's also kind of a key one as well. So I just think this kind of landscape, the complexity here, the potential interaction of all of these laws together really creates challenges in relation to transparency anyway. But when it is reported that, law enforcement aren't doing the right thing, they're not obtaining warrants to access journalists' information, et cetera, et cetera, et cetera. It seems like it's just, there's relative impunity, like there's no serious consequences that are even imposed on them for doing that. So I think, there are real issues and a whole range of concerns with that. And so I hope that kind of addresses the question.
It does, but we have two more questions that we want to quickly answer before we end this session. So we've got one from Jo. Could the panel please speak to how activists may be impacted by this bill? Activists that have recently been targeted, overcharged with incitement or criminal damage, etc., charges which are later dropped but may trip off powers of this bill?
Yeah, perfect. So look, last week I spoke at a panel for the Melbourne Legal Activist Support Centre, and they raised this as a key concern for them as well, particularly given, these warrants could be applied for, to investigating around sort of offences that using a computer punishable by a maximum penalty of 3 or more years imprisonment, including incitement. So it could be applied to activists organising protests, organising sort of locking on in respect to various protest movements, a whole range of kind of concerns here. And that goes directly to the issue that Angus and I have, discussed today, but also detailed in our submission, that the broad scope of applicability here in terms of, the kind of criteria and cutoff of what they can apply these for is well beyond, the justification or the rationale supporting the introduction of the bill. It's drafted so broadly, there's clear potential for government or, law enforcement overreach in application, but also in relation to the way in which they're defining a criminal group as an electronically linked group of individuals. So any two or more people who use the same electronic service, such as a website, or communicate with other individuals in a group electronically. So you could have like a WhatsApp group or a Facebook Messenger group or something like this, and be discussing a protest or something, and the government can hack you, take over your accounts, etc., etc. I mean, really, 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 really problematic.
It absolutely is. One more question, Angus, if you can answer this real quick, because we're going to have to end this session. So what role do you think the Information Commissioner could play in regulating some of the powers created by the various telco laws, noting the upcoming Privacy Act reform?
It's a very good question. And there's a long answer and a short answer, and I'll take the short answer. Supervisory and oversight is the primary role. In the context of reporting, the Information Commissioner could be given more access to what use warrants are taking and how they're being issued. But I think really the Information Commissioner can only be that supervisory oversight role. The real check and balance and the real role would need to be an enforceable human rights framework and judicial issuing of these warrants that can be the subject of proper scrutiny and proper argument in the court.
Okay, well, thank you so much. I'd like to thank our panelists, Dr. Monique Mann and Angus Murray. Thank you so much for making this EFA Talks so interesting. And thank you for the questions from our audience. It's been absolutely wonderful having you all joining us today. A big thank you to ThoughtWorks and Robin for your ongoing support to make these talks happen. EFA Talks will be back next month. And if you're not a member of Electronic Frontiers Australia, please join us. Check out our website, efa.org.au. EFA is an independent non-profit association that relies on membership, subscriptions and donations. So if you're concerned about digital rights in Australia, please join us or donate today. If you have any comments or topic interests, please get in contact with us, as we would absolutely love to hear from you. And again, thank you everyone for joining us. Have a wonderful afternoon.